was scheduled for jury duty, but ended up not being needed. And several of you inboxed me requesting a follow-up, but Jenna9099 was the first to do it, so Jenna, this is for you. I hope you enjoy this episode as much as you did the last. For those of you who haven't seen the first video, basically what I'm going to do is read several case cards from a board game called Judge for Yourself, and these are real legal cases from around the world, ranging anywhere from the 1600s up through the mid-1990s. And after I read the case synopsis, I'll briefly talk about it, what I think, how I think the court ruled, and then I'll turn the card over and read the actual verdict that the court decided, and usually there's a short explanation about why they ruled as they did. So I'm going to try not to move my hands or anything too much because I moved the camera closer to the actual table here because I wanted you to be able to read the card as well if you wanted to. And sometimes the moving the card up and down might force the camera to focus. Not that you'll hear the focusing, but sometimes it can be a distraction. So I'll do my best. So let's get to it. Case number 1: Survival of the Fittest. In 1884, a storm off the Cape of Good Hope forced a ship's crew to use the lifeboats. 3 men and a 17-year-old boy were in one boat, which floated for days without a sign of land. They quickly ate the provisions on board, and it was decided by 2 of the men that they should kill the extremely weak and dying boy and eat him. They did this and were picked up 4 days later by a passing ship. The 2 men were charged with murder on their return to England. Did the court rule for or against the 2 men? Well, first I should say, just like last time, I've never read these cards. So you and I are reading them for the first time, so I don't know how the court ruled in any of these cases, but upon first reading, I'm going to say that the court ruled against the 2 men for one reason only. Because they killed the boy and then ate him. It's not the cannibalism, it's not the eating of him that was the problem, I think. Because this has happened before. You hear stories of this happening sometimes when planes crash or hikers get stranded, that those who are survivors will end up eating the remains of those who have passed away. And so I think the court is going to distinguish the difference between eating an individual who passed away of starvation or passed away of injury versus actually killing somebody for the sole purpose of eating them, regardless of the extenuating circumstances. But who knows? Let's find out. So did the court rule for or against the 2 men? I think they ruled against. Verdict: the court ruled against the 2 men and held that it was not justifiable to kill, quote, an innocent and unoffending neighbor just to save one's own life. The 2 men were sentenced to death, but the Queen commuted the sentence to 6 months in prison. So that's exactly what it was. Since they actually killed this boy to eat him, therein lies the problem. They were fortunate that the Queen stepped in, though, because that's a pretty big difference, going from a death sentence to 6 months in prison and then restaurant's owner, Lewis, sued Harry for several $1,000,000, claiming that the review lost him business, injured his professional reputation, and caused him personal humiliation. Harry responded that the review was fair and not malicious. Did the court rule for or against the restaurant owner? On first read, I would say that they ruled against the restaurant owner. I think most people understand that a food critic or a book critic or a movie critic or an art critic, somebody who's being critical or critiquing another individual, is a subjective endeavor. And so what one person finds distasteful, another may find perfectly fine. And I think when people read restaurant reviews, they are conscious of that fact. So the food critic, Harry, felt that the service and food was bad, and he's perfectly entitled to feel that way and express his opinions. I don't see how he could be held responsible. It reminds me, somebody posted on Facebook, I'll have to put it up here in the video. It was a picture of a chalkboard menu that restaurants will sit outside to display specials or what have you. It was funny, it read something to the effect of, come in and try the worst meatball sandwich one guy on Yelp ever had. And I thought that was really funny. I thought it was so clever on behalf of the restaurant, because I've read terrible reviews of restaurants, and when I've gone to eat at those restaurants, I've had perfectly lovely experiences. So I actually think it's funny. And if I had passed that restaurant with that chalkboard sign out front, I definitely would have gone in just to have experienced the meatball sub or meatball sandwich, whatever it was, for myself. So at any rate, I think because it was a critic that the court is going to rule against the restaurant owner, but let's find out. Verdict. The court ruled against the restaurant owner. The court felt that ordinary, reasonable persons would see the review as the writer's opinion. So there you go. Which I think he's entitled to have. Now, there's a difference between being malicious and being critical. So, but there you have it. Case number 3. The deprived wife. In the early 1950s, a woman went to court asking for support from her husband, whom she had been married to for 30 years. They had lived in a one-room cabin with no plumbing, and the only clothing he ever bought her was a coat in 1950. He owned property and had over $100,000 in savings, but had not given her money for groceries until recently, when her health stopped her from her small income from selling eggs. She did not seek a divorce, only an increase in support from her husband. Did the court rule for or against the woman? Well, I really hope they ruled for this woman, because this guy sounds like a dirtbag. After 30 years of marriage, he only ever bought her one single coat. And it was close to, because if this case came in 1950s, that could be anywhere from 1950 to 1959, and they had already been married for 30 years. So they had to have already have been married for at least 20 years before he bought her a coat. They lived in a one-room cabin with no plumbing, but he had $100,000 in savings. Now in 1950, I think inflation has probably gone up probably 9 or 10-fold in the last 60 years. So having $100,000 in savings in 1950 in today's money would probably be between $900,000 and $1 million. And if he can't bring himself to provide her with a slight increase in support for groceries to feed her and him, I presume, then she's got a whole mess of other problems and needs to leave this bastard. But that's another case, I guess. Because look at, she's not even asking for divorce, she's just asking for an increase in support. So out of control. This guy's out of his mind. Alright, did the court rule for her against the woman? I really hope they ruled for her. The state Supreme Court ruled against the woman. Originally, the lower court had ordered the husband to give her $50 a month. So, in today's money, probably close to $500, a new car, and trips to see her children. In addition, he was ordered to repair and remodel the house, including new appliances. However, the state Supreme Court reversed the decision, saying that unless they were separated, a wife could not sue her husband for support. Wow, that's really interesting. So, initially, the district court, the lower court, agreed with the woman, and the judge was probably so incensed that this piece of shit was treating her so badly that this judge ordered him not only to pay her more in support every month, but buy her a new car, send her on trips to see her children, and repair, remodel the house, and buy all new appliances. So this judge knew what's up. Now the only way that it could have got to the state Supreme Court was that the husband appealed the ruling, which is why it went to the state Supreme Court. So he's a real big piece of shit because he doesn't obviously think his wife deserves anything more than a one-bedroom shack with no plumbing and a single coat. So she should have murdered this son of a bitch in his sleep and taken all the money and been done with it. That's out of control. So the court ruled against her. That's unfortunate. Alright, case number 4. A gas leak. An oil company in Canada owned a gasoline storage tank that developed a leak, causing gasoline to escape under Sedley's house. The fumes permeated into the house during wet weather in the spring and fall. Sedley filed suit against the oil company for inconvenience and for depreciation of property value. The oil company was only willing to pay for the inconvenience, claiming the fumes would disappear in a few years and not affect the property value. Did the court rule for or against Sedley? Well, just on first read, and this being a case involving an oil company, Big Oil, I have no doubt that they ruled against Sedley because oil companies, as I'm sure all of you know, they just wield so much power in politics and in the legal system. It's absolutely insane. So it wouldn't surprise me at all that this oil company probably isn't going to be held responsible for a malfunction of one of their machines or gas lines. But let's find out. Did the court rule for or against Sedley? They probably ruled against. Verdict: the court ruled against Sedley and held that because the fumes would eventually dissipate, the property would not depreciate unless Sedley planned to sell the house before then. So there you go. Absolutely ridiculous. So basically they're telling this guy dissipate in a few years. You'll be fine. Ridiculous. Absolutely insane. Now, mind you, if one of the oil executives were forced to live in that house with those fumes, you can bet your ass that not only would the problem have been fixed immediately, but the fume situation would have been taken care of instantly. So, it's just out of control. It really upsets me how much power and how irresponsible these oil companies are. It was just reported yesterday, Tuesday, that I'm sure most people remember, even if you don't live in the United States, back in May of 2010 when the Deepwater Horizon oil rig exploded in the Gulf of Mexico and spilled, I think it was 4.9 million barrels of oil, 212 million gallons of crude oil into the Gulf. It was just reported yesterday that businesses are still suffering like they never have before in history. People's medical bills, those individuals who were hired to clean up the mess, are now suffering incredible loss as far as health. They're developing tumors and all kinds of cancers from the chemicals that were used to clean up the oil. And BP, British Petroleum, isn't helping at all with any of the medical bills or anything, and they just posted a $4.1 billion profit for quarter one of 2013. So, again, no responsibility taken for their actions. All that matters is profit. So, ridiculous. Alright, case number 5, I think this is. It wasn't me. Mrs. Duffy was suspected of running an illegal gambling business from her home. The police knocked on her door and announced their business. Someone inside said, "Come in," so they did. Upon entering, they found Mrs. Duffy and a female companion with incriminating betting materials. Mrs. Duffy asked that the material not be admitted as evidence because she was not the one who had invited the police in. Her friend was the one who had spoken. Did the court rule for or against Mrs. Duffy? I think this is pretty open and shut, black and white. I would say they ruled for Mrs. Duffy. If you don't own the property or you're not residing at the property, you can't give permission for police to search the property. And I think anything, and if they do search the property on somebody's false permission, then I think the material should be inadmissible. But who knows? Let's find out. Verdict. The court ruled for Mrs. Duffy because consent to search can only be given by one who could have resisted the search as invasion of personal rights, or somebody authorized by him or her to consent to the search. So that makes sense. Although why the friend of Mrs. Duffy would have even shouted, "Come in," knowing that there were police at the door and knowing that they had incriminating evidence just sitting in plain sight is beyond me. So Mrs. Duffy should probably rethink her acquaintances. Alright, case number 6. Suing the Astrologer. A woman in Hawaii enjoyed going to her astrologer and having him predict her future. During the year she visited him, he predicted that she, among other things, would receive a very large check in the mail, her income would triple, and she would become the owner of 3 apartment buildings and a condominium. When none of these predictions came true, the woman sued the astrologer for the $10,000 she had paid him. Did the Florida District Court of Appeals rule for or against the officer? I think that's a typo. This this has nothing to do with this case up here. So did the court rule probably for or against the woman? I'm sure they would have ruled against this woman. First of all, anybody who pays $10,000 to an astrologer in a single year is, I think, a little loopy. But to sue somebody because they incorrectly predicted the future is, I think, a bit of a stretch. You know, this kind of reminds me of, so this woman was promised that through the course of the year, a large check would come in the mail, her income would triple, and she would become the owner of 3 apartment buildings and a condominium. The astrologer probably neglected to mention, or maybe it's just common sense, that when that whole, I think it was, goodness, like 2005 or 2006, when that book The Secret came out, the law of attraction, if you think about something enough, you will draw it into your life, like attracts like, which I believe to a certain extent, but you can't sit on the couch and, dream of a Ferrari suddenly showing up in your driveway. It's an active process. You have to actively engage in working towards that, and then the universe will align things for you to make certain things happen. It's not a matter of, all right, I'm going to sit, on the couch for the next 6 months, and at the end of 6 months I want to be a millionaire and have a brand new car. So if this woman, instead of paying $10,000 to her astrologer, would have taken that money and invested in a down payment on the apartment buildings and the condominium, she may have tripled her income and therefore would have received a big check in the mail. But instead of doing that, she chose to just give the astrologer the money and say, tell me what I want to hear. So I hope they ruled against this woman. She's out of her mind. The Hawaii Supreme Court had to decide whether predictions of the future can constitute fraud if they do not come true. The court said that fraud is based on the misrepresentation of facts which are known to be false. In this case, because the facts are misrepresentations of future events which the astrologer could not have known to be false, the court ruled against the woman. So, absolutely. Open and shut. Case number 7, I believe. Neither a borrower nor a lender be. Sylvia asked her neighbor Fred if she could borrow his stepladder to change a light bulb. Fred told her that one of the support braces was loose, but Sylvia decided to borrow it anyway. The ladder collapsed while Sylvia was on it, and she broke her arm and 2 ribs and was out of work for weeks. She sued Fred for compensation for her injuries, claiming she should not have been lent the ladder if he knew it was dangerous and could possibly collapse. Did the court rule for or against Sylvia? Again, I think this is pretty clear-cut, open and shut. They, I'm sure, ruled against Sylvia. If Fred told her that the stepladder was, for all intents and purposes, broken, if one of the steps of a ladder is loose, then it's probably a good idea not to use the ladder for the very same reason that happened to Sylvia. So if Fred told Sylvia about the issue with the ladder, and Sylvia still borrowed the ladder knowing full well the danger that was present, then in my mind she waived all responsibility for it, and she took on whatever happens to her. So if Fred knew that the his negligence, or, who the hell knows, but I think Fred said, listen, this damn ladder's broken, you want to use it, it's up to you, but I'm not going to be responsible for it, so I think they rule against Sylvia. Verdict: the court ruled against Sylvia because it held that Fred's verbal warning was sufficient, and Sylvia had assumed the risk of injury when she borrowed the ladder anyway. If an individual borrows something and is injured while using it, he cannot be compensated by the person who lent it unless that person knew the item was dangerous and did not give sufficient warning. Absolutely. Common sense, open and shut. Sylvia's an idiot. Case number 8. Suicidal tendencies. The parents of a disturbed teenager decided their daughter needed help and took her to a psychiatrist. The daughter had become a drug user and had talked to her friends about suicide. When the girl committed suicide by a drug overdose, the parents sued the psychiatrist for not acting on his knowledge of her suicidal tendencies. They claimed it was similar to a case in which a psychiatrist failed to warn victims of a homicidal patient and was held liable. Did the court rule for or against the parent? This one I think is a little trickier because I don't know what the rules are for doctor-patient confidentiality. And if this young girl was a teenager, I certainly don't know what the doctor-patient confidentiality rules are regarding underage minors. So that's a tough one to, did the court rule for or against the parents? I'm going to say against the parents because only for one reason. I think that even if the doctor had told the parents that she had these tendencies, that would still not have been any guarantee that she wouldn't have committed suicide. And using that same logic, why didn't the parents sue her friends? Because it says that the daughter talked to her friends about suicide as well, so her friends also knew, just like the psychiatrist, but the friends didn't come to the parents and say, hey, listen, this is what your daughter's thinking about doing. So that's a tough decision, but I think that the court ruled against the parents, but let's find out. Verdict: the court ruled against the parents and held that the psychiatrist's decision to keep what he knew confidential was entirely so. Alright, so that's not a very good explanation, but it is what it is, so. Alright, last one. Case number 9. Still jumping. On a beautiful summer day, Jerry hired a horse from a local stable for an afternoon ride. As he was galloping through the open countryside, all of a sudden, for no apparent reason, the horse jumped. Jerry was thrown off the horse, and as a result, both of his legs were broken. He later discovered that the horse was a retired show jumper. Jerry filed suit against the stable that owned the horse for negligence. Did the court rule for or against Jerry? This is an interesting one. On the one hand, I understand that if you ride a horse, that is an animal. It has a mind of its own. And sometimes animals do things that, that can't be explained. I actually live in an equestrian community. Everybody has horses. I shouldn't say everybody. I don't have horses. But I see the horses. There are, a lot of them are show horses, and people have the, I don't even know what they're called, but all of the jumping stations and everything all set up in their yards, and with the sand fields and all that stuff for training, and horses jump. I mean, that's what they do. I think especially if a horse gets startled, if there's a snake or something, they jump. That's just, I jump when I see a snake, so, I understand that tendency, but I guess another question is, should this stable have let Jerry know that this was a retired show jumper? Our jumping horses are performance horses more keen on jumping than regular horses? I don't know. That's interesting. I'm going to say that the court ruled against Jerry, because if you get on a horse, you're taking that on. That is your responsibility. Which is why I don't ride horses, because they're unpredictable, I think, in some circumstances, and I don't feel like being thrown from a horse. Verdict: the court ruled against Jerry on the grounds that the stable keeper was not required to tell Jerry that the horse was a jumper, because he had no reason to believe that the horse would jump in open countryside where there were no hurdles. That's the word I was looking for earlier, hurdles. So, that makes sense, I guess. But at any rate, so that's it. Like I mentioned in the last video, if you watched it, this board game originally came with 500 of these case cards, and at one point years ago, I separated like 40 or 50 of them out for a road trip with some friends, thinking that we might use them if we got bored, but we never did. And since then, I have subsequently lost the board game and all of the cards except for these original 40 or 50 that I separated for the road trip. So I did 9 here. I think I did 9 last time, so that's 18. So I might have another, 20 or 30. I guess I can count them. So I think these are fun. I like reading the cases and seeing how the courts roll. So if you'd like to see a third rendition, by all means let me know. Otherwise, I am going to get going. I'm going to start dinner and get this posted for you guys. Alright, so I appreciate you stopping